On behalf of the Line 5 organizing team, thank you for joining us this evening for our special campaign briefing, Line 5 at the Supreme Court Crossroads. My name is Julie Geisinger, and I'm the organizing coordinator for the Oil and Water Don't Mix Coalition and a Line 5 organizer representing the Sierra Club Michigan chapter. I'm joined this evening by my fellow organizers, Dr. Nicole Kiwe-Biber, Lila Hollis, Erica Bolden, and Ross Fisher. I'd also like to give a shout out to Bill Latka and David Holtz from OWDM who are on the call this evening. Before we jump into the guest speaker for this evening, let's just take a quick look at tonight's agenda. Okay, we're going to share some brief updates on tunnel permitting and a rally planned for this March in Lansing. We'll be joined by special guest Riyaz Kanji for a breakdown of the Supreme Court case Enbridge v. Whitmer, discuss how we got to this point and the implications this case could have, and then we'll end tonight's call with an important action you can take. At any time during the call you have questions, please feel free to write them down in the chat and we'll do our best to answer them. And after our guest speaker, we'll also have some time for some Q&A. So to begin, it looked like in the chat there was several, but if there's anybody on tonight's call that's making your way here tonight and this is your first Line 5 call, you're not familiar with the issue, would love to see either a show of hands or write in the chat new, because we're happy to do a quick 1-minute download on what Line 5 is for those that might not be super familiar. So if you either just raise your hand or put new, if not, we'll just skip over this. Oh, we do have several new ones. Okay, I'm going to do my quick 1-minute elevator spiel of Line 5. So bear with me here. Okay, Line 5 is a 72-year-old oil and gas pipeline owned by Canadian corporation Enbridge. It runs 645 miles long, starting in Wisconsin, cutting through Michigan, and ending in Canada. Line 5 is basically a shortcut for Canada's benefit, with less than 5 to 10% of the product used in Michigan. There have been over 30 documented spills since the late 1960s. It poses a continued threat to the Great Lakes, which contain 20% of the world's fresh surface water, 90% of the fresh water in the United States, and drinking water for 40 million people. A 4-mile segment crosses under the Straits of Mackinac, one of the most ecologically sensitive areas in the world. These dual pipelines currently lay along the bottom of the lake bed and have been damaged in the past by anchor strikes in the busy shipping channel. Enbridge wants to build a tunnel under the lake bed with a new pipeline segment. In Wisconsin, there's also a highly contested section of the pipeline that crosses the Bad River Band's reservation, and a proposed reroute is in the litigation process. So hopefully that gives you a little bit of a download on what Line 5 is, and we thank you for finding this space tonight and joining us. All right, we're going to move on to some updates now as far as the tunnel permitting goes. Michigan Public Service Commission approved their permit back in 2023. This decision was appealed and is now making its way to the Michigan Supreme Court. Oral arguments will take place this March. Riyaz will discuss this case more shortly. Enbridge is also seeking several permits from the Michigan Department of Environment, Great Lakes, and Energy, also known as EGLE. Most importantly right now is the Clean Water Act Section 404 permit, which governs permits for dredge and fills and waters, wetlands, and fisheries. The state of Michigan can deny a 404 permit with a project when it would have significant negative impacts on its waters and the aquatic environment. So essentially, if the state denies the 404 permit, the Army Corps can't issue their federal permit. A decision is expected by the end of the month on this. This is the state's last opportunity to protect the Great Lakes. Governor Whitmer and EGLE have the power to deny these permits and stop Enbridge from building the tunnel. We need to keep the pressure on. Erica will be sharing the decision watch action in the chat. If you haven't taken this action already, please do so. And if you'd like to do more, you can also make calls to the governor. You can find details on how to do this in a script under the Take Action tab of oilandwaterdon'tmix.org. I'd also like to flag that the EPA recently proposed a rule change to the Clean Water Act Section 401. This could impact the EGLE permitting decision. Nicole will go over these proposed rollbacks in more detail and share out the action we hope you'll take tonight at the end of the call. And finally, the final environmental impact statement, the EIS, was released last week by Army Corps of Engineers, and its findings confirmed the tunnel would cause permanent harm to the Great Lakes, from the permanent alteration of geology, long-term wetland losses, and sustained impacts from pollution. There was some concerning information in the final EIS. Among these findings, the tunnel got longer. The final EIS describes a 3.9-mile tunnel, up from 3.6 miles in the draft. And that's an immediate scope change that affects the impacts, the construction duration, and spoil volumes. The lake bed footprint got bigger. The final ES states about 38 acres of lake bottom would be affected versus 31.4 acres. So the larger tunnel length and the increased lake bed conversion strengthen the arguments to revisit the alternatives analysis and bolster arguments for the state to reject the 404 permit, which is all the more important that we put more pressure on the state and on Governor Whitmer right now. So a record of decision from the Army Corps will be announced in March. So moving on. So as the tribal nations and environmental groups head to the Michigan Supreme Court this March, we hope you'll join us there for a rally. We're also planning to gather and listen to the oral arguments together someplace near the courthouse. The oral arguments will either take place March 10th, 11th, or 12th. The exact date will be announced next week, so stay tuned for details. Lila, would you like to share details on the Up North organizing effort for this?
Sorry, I couldn't find my mute button. Yes. So if the bus is go or if the Supreme Court hearing is March 10th or 11th, um, Oil and Water Don't Mix is going to be hosting a bus from Traverse City down to Lansing and back up after the hearing. And groundwork is going to be organizing to get people on that bus, as well as I think Flo is going to help get some people on the bus as well, and maybe Nemiak. So if that's of any interest, you can feel free to email me. We're hoping that it's one of those days. That way we have public transportation down and back. But that's about all I have until we figure out the exact date for that trip down.
Perfect. All right, thanks, Lila. I'd also like to give Lila a shout out. She put together a great visual of the legal cases. We'll drop that handout link in the chat now. On our January call, when we were talking about the legal updates, it's kind of confusing and cumbersome. So she put together a nice visual for us that prefer visuals. So that'll be in the chat. Okay. Now, I'd like to introduce our guest speaker for the evening, Riyaz Kanji, one of the nation's leading tribal rights attorneys and founding partner of Kanji and Katzen. Riyaz brings unique insight to the Line 5 case, and we're thrilled to have him here this evening, where he'll share how we got here, break down the legal strategies, constitutional questions, and potential outcomes of this pivotal case. Riyaz, it's all yours.
Good evening, everyone. Thank you, Julie, and thanks so much to the Oil and Water Don't Mix Coalition. It's a real privilege to be speaking here tonight, and thank you for everyone who has turned out to listen. We always so appreciate and benefit from the tremendous support for all the litigation efforts, the widespread interest in the case, all the work, the tremendous work that the advocates do puts a lot of wind in our sails. And this has been such a long-standing battle on many fronts that we derive tremendous energy from the support. It is said that the Line 5 battle never sleeps. Just this week, we are working on two briefs due on Friday, one in the Bad River matter, and I'll come back to that at the end. And the final brief in the Michigan Supreme Court tunnel proceedings that Julie mentioned. And I will talk about the Michigan Supreme Court proceedings at the end of my talk as well. First, I will address the United States Supreme Court proceedings. So as you see, there are multiple courts and multiple fronts. I will try these U.S. Supreme Court proceedings get legally pretty dense, but I'll do my best to explain things as clearly as I can, and I want to make sure to leave as much time as possible for questions because the interactive part of these webinars are always the part that I enjoy the most and learn so much from people's questions. But to take a step back and to talk about the different lawsuits, this all began, as many of you remember, in state court with the Michigan part of the Line 5 case, bracketing Bad River and what's happening in Wisconsin. But the Michigan part of the Line 5 proceedings started off simply enough with a lawsuit filed by our Attorney General, Dana Nessel, in June of 2019, making good on her promise to bring a lawsuit to shut down Line 5. Attorney General Nessel's suit was brought in Michigan State Court. Now, a word on state and federal courts, and this is very relevant to the issue that the United States Supreme Court is about to hear. State courts are what we call courts of general jurisdiction. They can hear claims that are based on state law or based on federal law. Federal courts, by contrast, are courts of limited jurisdiction. They can only hear cases that are based on federal law claims. And moreover, that means that the plaintiff's case has to be based on federal law. If the defendant in a case raises a federal defense, a federal law defense, that does not suffice to create federal jurisdiction. State courts can hear those federal defenses as part of adjudicating a lawsuit. The final principle on this, the plaintiff is deemed the master of her complaint. So if a plaintiff frames a case as a state law case, that is meant to be determinative of of which court has jurisdiction. And that's what Attorney General Nessel did. She framed her line five claims as state law claims. She based the effort to shut down line five on the public trust doctrine. Many of you have heard about the doctrine in the context of the pipeline. That's a state law doctrine, a venerable common law state law doctrine that holds that the state holds the bedlands of the Great Lakes, the bottomlands in trust for the people, and that her claim was that the initial installment of the pipeline and then the continued operation of the pipeline violated the public trust. So, a state law claim. She also brought claims under the Michigan Environmental Protection Act, a state statute, and the state's public nuisance law. So, for very legitimate reasons, she filed her case in state court for the state courts to adjudicate those critical state law issues. And her case initially proceeded the way that a case normally would proceed. Enbridge filed an answer in state court. It raised defenses, which were federal law defenses, including the argument that the Pipeline Safety Act, the Federal Pipeline Safety Act, preempts the state's claims. But it raised that in state court. And Judge Jamo, the state court judge, he held arguments on both on the state's public trust claims and on Enbridge's defenses, preemption defenses. He did that in 2019 and 2020. There was a lot of briefing. Things were sort of evolving in a sane kind of way. Then a couple things happened. First was that in the summer of 2020, as many of you will remember, the pipeline was struck. There was one of these infamous anchor strikes, and the state moved for the pipeline to be shut down, at least temporarily, while there was an assessment of the damage to the pipeline. And there were emergency hearings in front of Judge Jamo, and he granted the state's request. The pipeline was shut down for a period of months while PHMSA, the Federal Pipeline Agency, and others assessed the damage to the pipeline. Ultimately, Judge Jamo allowed the pipeline to be reopened when PHMSA deemed it safe to do so. But Enbridge, I think, was a little shook by the fact that the judge had ordered even a temporary shutdown of the pipeline, and likely began to worry about whether the judge was going to be a favorable decision maker for it or not. Then in November of 2020, after a lot of advocacy, a lot of efforts directed at the governor issued her notice revoking Enbridge's easement across the straits for the pipeline, and simultaneously terminating that easement for violation of its conditions by Enbridge. And at that time, that was a happy event, and that was something that many people on this call worked very hard to accomplish for the governor to take that step. Simultaneous with that notice, the Attorney General filed a new lawsuit on behalf of the governor to enforce her revocation notice. And that's when the fun and games started, the procedural fun and games. Enbridge very quickly moved to remove the new lawsuit to federal court. And there is a process. If a case is brought in state court, but it is a case that is based on federal law, you can remove that case to federal court. And the way the process works, a defendant can automatically remove the case to federal court. Then the federal court decides whether the case was properly removed. So it's the federal court that plays that gatekeeping function. The state court can't stop a case from being removed to federal court. But if the federal court decides that a case was improperly removed, it sends the case back to state court. So Enbridge removed the case to federal court, even though the governor's claims, the claims in the governor's suit, were fairly similar to the original suit brought by the attorney general. They're based on this notion of the public trust doctrine. That's what the governor rested her revocation notice on. But two things had happened between when the attorney general originally filed her suit in June of 2019 and the filing of the governor's suit in November of 2020. First, as I say, Judge Jamo had held these proceedings and ordered the temporary shutdown of the pipeline. And I think that shook Enbridge a little bit. Secondly, more generally speaking, in the fossil fuel industry, there had become an increasing reliance on removing cases to federal court. The fossil fuel companies, pipeline companies, but also producers, Exxon and they're like, had realized that it sort of developed this conscious strategy of wanting to be in federal court on the theory that many of the federal appeals courts and definitely the United States Supreme Court had become more and more conservative and were likely to be a more favorable forum for their issues than state courts like the one we have in Michigan, which now, even by 2019, 2020, and even more so now, had become perhaps more progressive courts, courts that were going to give a fair hearing to environmental claims. And so removal actions were happening all over the country. And I think Enbridge figured out that, oh, this is a pretty good strategy. So they removed the governor's case. It was then up to the federal trial court judge, who at the time was a judge named Janet Neff in the Western District of Michigan, to decide whether to send the case back to state court. And this is where the problems really began. That was an easy open and shut case where Judge Neff should have sent the case back to state court because, as I say, the claims are based on state law, and the attorney general had the right to frame her claims based on state law. But Judge Neff did two really damaging things. First, she sat on the removal issue for almost a year. It took her almost a year to decide whether to send the case back. And in the context where, as you all know, we're talking about a pipeline that had a near miss where there's urgency to the situation, that was really unconscionable for her to take that long to decide. And then, to make matters far worse, she decided it in the wrong way. She decided that she could keep the governor's case, that even though it was framed as a state law case, her reasoning was that there were federal law issues that so predominated in the case that essentially affected or influenced how the state law claims would be decided, that really the case was federal in nature. And she talked about two things. One, that Pipeline Safety Act that I mentioned. But secondly, by then, Canada had become very vociferous about its interests in the case and about the 1977 Transit Pipeline Treaty, which many of you know about, which Canada claims prevents a shutdown of a cross-border pipeline, and had asserted its interests, had filed for mediation under the treaty, and had let the courts know about these claims of its. And Judge Neff said, this is an internet issue of international importance. There's a federal treaty involved. It's really a federal case. So she decided to keep it. At that point, the governor dismissed her case on the very sound basis that it was going to be hugely, at the very least, very complicated, and at worst, highly problematic to have a suit proceeding in state court, the attorney general's original case, and then this second case, the governor's case, proceeding in federal court. And so the idea was let's just simplify things, keep them simple, and defer to the attorney general's case, which was further ahead in time and where the state court had already held, as I said, hearings. And the state court at that point, I should say, had been waiting for to see what was going to happen with the federal case and whether it was going to get sent back to it. So the delay again was very hurtful. But the governor dismisses her case. So then one thinks, okay, the attorney general's original case is going to proceed in state court, and we'll get to a decision on the merits of the issues. But that was not to be because Enbridge then did something very interesting and strategic, which was at that point in time removed the attorney general's original case to federal court. And this is very directly relevant now to the issue that's going to be heard in the U.S. Supreme Court. It did so over 2 years after the attorney general had initiated her case, and did so in spite of a rule, a clear-cut rule that you have to remove a case to federal court within 30 days. There's a very clear federal rule of procedure that says if you're going to remove a case from state court to federal court, you have 30 days to do it. And there are obvious reasons for that rule, which are that you don't want somebody to start litigating a case in state court, have things unfold, decide at a certain point in time that things aren't going so well in state court, and then remove a case to federal court. And that's exactly what Enbridge did. As I said, it had reason to be concerned about Judge Jamo. There was already a lot of water under the bridge in that case. It didn't like the way things were going, and so it removed the case. And this is the second grave injury that Judge Neff caused. Instead of sending that case back, the Attorney General's case, immediately based on the 30-day rule, she again sat on the removal issue for almost a year and then ruled the wrong way again and held that the 30-day period was excusable, that it wasn't a firm rule, that it could be excused. She was going to excuse it because Enbridge couldn't really have known that its case was a federal case until she ruled that the governor's case was a federal case, and that again, federal law issues predominated. So this was a shock of a decision. All of us involved, the state was completely flummoxed. There was cause for a great upset. The state appealed that decision up to the Sixth Circuit, the federal appeals court that governs Michigan. And that appeals court panel, which I will say consists of three Republican appointed conservative judges, reversed Judge Neff and said in pretty clear and stark terms that she had been wrong to ignore the 30-day limit in the federal rules, to treat it as a discretionary rule rather than a hard and fast rule, and sent the case back to state court, the attorney general's case. So then one thinks, okay, finally, and now years have passed because of all this, and really just a terrible loss of time, that we're going to be able to finally go ahead in state court. But then another thunderbolt, the United States Supreme Court granted Enbridge's petition to take the case up and hear this issue about the 30-day provision and whether that's a firm rule or a discretionary rule. It took the case up, I think, because there was another circuit court that had ruled the other way from the Sixth Circuit, that had ruled that the issue was discretionary, that the rule was discretionary. And when there is a conflict in authority between two different circuits, that's a classic basis for the Supreme Court to take up a case. So we don't read into the fact that the Supreme Court has taken up the case any that it's necessarily hostile to what the Sixth Circuit ruled. That's the first point about this case. Secondly, and this is obviously my recitation here has been very procedural and legal in nature, even though the Supreme Court now has a case in front of it involving Line 5, the issue it is deciding is nothing to do with the ultimate merits of Line 5 or the safety of the pipeline. It has to do with this question of which court the case belongs in. Having said that, it's a very important decision, both for this case, for the Attorney General's case, and for challenges to the fossil fuel industry more generally. If the Supreme Court rules in the Attorney General's favor, then there will finally be a decision that her case belongs in state court and can proceed in state court. If it rules against the Attorney General, the case doesn't automatically stay in federal court. It will get sent back to the Sixth Circuit, which will then have to decide, leaving aside the deadline, whether Enbridge's argument that this is really a federal case in a state court or rather than a state case is correct. If it decides that because of the Transit Treaty and the Pipeline Safety Act that this is truly a federal case, it will keep the case in federal court. If it does what we think it should do and decides that no, this is really still a state law case, it would still send the case back to state court. But that would take another year or so. So the hope is that the Supreme Court determines that the rule means what it says, that 30 days is 30 days, that Enbridge was more than 2 years too late in removing the case and sends the case back. So it's a procedural issue that's ultimately at stake, but one that could have a significant decision, effect on where the Line 5 litigation goes. I am going to stop there on the Supreme Court. I'll be happy to take questions about any of that. I want to take just a couple of minutes and talk about the Michigan Supreme Court proceedings, and then we can go to questions. The Michigan Supreme Court proceedings have to do with the other huge front in this battle, right? There's the fight over the existing pipeline, and then there's the fight over whether Enbridge can build a tunnel, bore a tunnel to house a new pipeline and effectively to lock in Line 5 infrastructure for another century. So a hugely consequential part of the battle. And there, the state court permitting, the state permitting process is divided between two agencies, and these are both very important. The Michigan Public Service Commission has the authority and needs to issue a permit for the tunnel because it controls utilities in the state, including pipelines. At the same time, Eagle, the state environment department, also has to issue permits because water resources are involved. The bottomlands of the Great Lakes and wetlands are both implicated. Eagle currently has permit applications in front of it. It is thick into deciding whether to issue permits. It issued permits 5 years ago for the tunnel, early in the Whitmer administration, but those permits had a 5-year expiration deadline on them. So Eagle is going through that process again, and I will say that it is going through it in a far more considered and detailed way under the direction of Director Phil Roos than it did the first time around. And that is a good thing. We don't know where that permitting will come out, but we can say that that is a very involved process, including a very substantial tribal consultation component, which is probably the best tribal consultation that I've ever seen or been involved in 25 years of doing this kind of work. The Michigan Public Service Commission, consisting of 3 Governor Whitmer appointees, did grant the permits after a very contested set of proceedings. Issued a very disappointing decision granting a permit for the tunnel, which the various environmental groups and tribes appealed to the Michigan Court of Appeals, which essentially rubber stamped the MPSC decision. But from there, the news gets better. The tribes, represented by Earth Justice and the Environmental Law and Policy Center, both filed a petition from the Court of Appeals decision, arguing questions about the proper standard of review and scope of review under the Michigan Environmental Protection Act. And then For Love of Water also filed a petition for review, and we are representing them based on the MPSC and the Michigan Court of Appeals misapplication of the public trust doctrine when it comes to permitting on the bottomlands of the Great Lakes. The Michigan Supreme Court granted both those petitions for review. So the argument that Julie mentioned, there will be arguments in two companion cases. They'll be argued one after the other, and those arguments should be extremely interesting and extremely important, both for the fate of the tunnel, if the Supreme Court agrees with the arguments being raised by the tribes and by Flow. It would end up upending the MPSC permit. The case is also very important in a more general sense because fundamental issues about the construction of the Michigan Environmental Protection Act are at issue, and the decision the court makes could have broad application to a lot of different types of environmental cases. So I'm going to stop there because I want to make sure we have time for questions. I know I covered a fair bit of ground, and there's some ground I haven't covered, including talking about the Bad River case. But we'll see what people are interested in discussing, and looking forward to a good dialogue. Thank you.
Thank you, Riyaz. We can either, if you want to raise your hand in the chat or drop your questions into the chat that way. We can see here. There was one question that I wanted to raise. So somebody asked, Sue asked, so will Enbridge be allowed to build while these cases move forward? So in theory, if the permits were all approved for the tunnel, could they start to start to do construction while the rest of the cases are going?
Yeah, it's a great question. It's complicated because there are so many different permits involved. But if we were to lose in the Supreme Court, then the MPSC permits would become finalized. They would still need to get the Eagle permits. If Eagle were to grant the permits, then the environmental plaintiffs, the tribes, would have to seek a stay of those permits in the state court system. And the state courts would have the final word on whether construction could proceed while the challenges to those permits were being litigated out, or whether the courts were going to stay construction until until they decided the case. There would not be an automatic stay. So really, ultimately, the state courts would control when construction could start, if and when it could start.
Okay, great. Erica, are you on? Have you seen any questions in the chat that you want to lift up?
Yeah, they're actually, let me just
Ashley also.
Oh, go ahead.
I was gonna say Ash also has her hand up, so I don't know which one goes first.
Yeah, I'll go ahead and just throw this out because I feel like we can get a pretty quick answer. Someone wants to know, once the Supreme Court hears arguments, how long it will take to reach a decision.
The court term ends at the end of June, early July, and they will decide the case by then. Cases argued in February, usually decided by May, early June, somewhere in there.
Okay, Ashley.
Thank you so much, Riyaz. This was really, really a great and helpful update. Just had a quick question about the Supreme Court taking up this case. I've heard that if the Supreme Court takes a case, then they can technically open the docket and review other issues. I know you said it's not likely and that they're really just trying to address that 30-day clock that Enbridge missed, but is there any concern from the attorneys that they may broaden the scope once they're in this one?
Yeah, great question. I don't think so, Ashley. I think they will restrict themselves to the procedural issue. The one risk would be that it's possible that in the course of writing the opinion, they might say something, a stray comment that could have some bearing on the case. For example, if they were to say something negative about the public trust doctrine, but it's very unlikely. I think, especially in this case, the procedural issue is so narrow that I think they will likely confine themselves to it.
Okay, that's reassuring. Thank you.
I can go ahead and pick out another question. Somebody would like for you to talk about the recent Army Corps of Engineer findings of harm and how that might fit into the case.
Yeah, so it's interesting. The Army Corps issued its final environmental impact statement this past week, and that environmental, next month, like within no sooner than 30 days, but quite likely shortly thereafter, the Army Corps will issue its final decision, its record of decision, because there's also a federal permit needed. This is for the tunnel. There's a federal permit needed. And I think, it's foreordained in this administration that the Army Corps is going to issue the federal permits. But there are two interesting things. One is that environmental impact statement did note and document that the tunnel will have significant environmental impacts. So even in this administration, the Army Corps, given the overwhelming evidence, did have to acknowledge that the construction of the tunnel is going to have significant impacts. Secondly, I think the messaging that has been coming out of this coalition and out of the various advocacy groups is exactly correct, which is that it's predetermined that the Trump administration is going to issue these permits. They've been fast tracked. They've got the executive orders, the national energy emergency and all that nonsense. So the battle really is in Michigan, and the fate of the tunnel rests with the Michigan agencies, with Eagle and with the Michigan Supreme Court and what it does with the MPSC permit. And that in some ways is as it should be, right? This is a matter of fundamental state concern, and it is only appropriate that the state government will have the final word here. The risk and the concern, as many of you know, is that there are all these efforts afoot to restrict state authority or to eliminate state authority because of situations like this where the feds are so intent on a project going through and state agencies are raising concerns. But at least for now, under the law as it is now, and we always have to caveat that these days, the state agencies will have the final, and the state courts will have the final word on the fate of the tunnel.
We have a hand up from Emily.
Well, I had a couple had these questions a couple of times before or on the chat, but I was wondering how you would counter the 1977 treaty point in that case, since it seems such a clobber passage, and I'm also wondering whether there's anybody in Canada's government you could ask for help with. I mean, I wonder if Canada would even want to go through with this deal anymore, given what went down in Davos. In Davos.
Yeah, so I'm not sure I quite heard the first question, but were you asking about the interpretation of this 1977 treaty and what the counter is to Canada's argument?
Yeah.
Yeah. Yeah, great questions. So a couple things about this. The 1977 treaty provides that no governmental authority in either country will take any action to impede the flow of oil in cross-border pipelines. That's what Canada and the Trump administration hang their hat on. But they ignore, that's Article 2 of the treaty. They ignore Article 4 of the treaty, which says very, very clearly that that does not preclude states from regulating in the service of various important state interests, including specifically environmental regulation, environmental protection. So the treaty itself that they place all this freight on could not be clearer in saying that states can regulate for purposes of environmental protection. So I think both for purposes of the tunnel permitting, which is clearly regulatory permitting, and the state is fully entitled to take environmental considerations into account, and the state's actions based on the public trust doctrine to terminate the existing pipelines likewise fall squarely within Article 4. On your second question, Canada, and I say this, I grew up in Canada. I'm very fond of my Canadian childhood, but I am so utterly disappointed in the Canadian government, which does a great job of selling itself as a progressive and environmentally friendly government. And there's no doubt the Canadians are more progressive than we are on certain issues at this point in time. But anything having to do with extractive industries, it does not, they are not anywhere remotely progressive. They've been terrible. And they've been a huge thorn in our collective side in this fight. And perhaps the most disappointing thing is that in our case on behalf of the Bad River Band in Wisconsin, where Canada plays all this lip service to respecting indigenous rights, after sort of tiptoeing for a while and dancing around, Canada is now full bore in that case as well, in trying to interrupt and disrupt what the courts want to do in awarding any relief to the band. And the new Prime Minister, Carney, who sounds like a great and reasonable guy on all kinds of issues, he's not our friend when it comes to these fossil fuel issues.
Okay. Ned?
Okay. Well, good evening. I'm a Wisconsinite and a friend of the Bad River folks, and my daughter lives in Michigan. But I'm wondering to what extent treaty rights have any traction in either one of these. We have this issue over here as well that's connected. Trying to get around the reservation, which incidentally, the reroute is full of water, wetlands and streams. It's basically headwater, watershed that goes back through the reservation into Lake Superior, Ramsar wetland as well. But yeah, the treaty rights are come in to play here somewhere. Probably being ignored. Just curious.
So yeah, great question. Thank you for asking it. Thank you for your friendship with the Bad River Band. I'll give a 1 minute update on the Bad River case, which ties in directly to your question, and then talk just a little bit about treaty rights in Michigan. In the Bad River case, as many of you know, the federal trial court judge did issue an injunction saying that the pipeline needs to shut down across the Bad River Reservation by June of this year, June 16th of this year. That decision was issued over 2 years ago. At the time when the judge issued the decision, he gave Enbridge 3 years to shut down the pipeline. We felt like that was a very long period of time. That was too long. But now that date is right around the corner. But we don't have a decision from the Seventh Circuit, the Federal Court of Appeals, which presumably will come at some point between now and June 16th. Enbridge is understandably getting a little anxious because that is a firm shutdown date. And it filed a motion last week with the federal trial court judge to suspend that shutdown. And when I say we're working on a brief that's due this Friday, we're responding to that. The brief it's an Enbridge classic. It comes with umpteen declarations attached to it from refineries, labor unions, all the like, talking about what a catastrophe it will be if the pipeline has to shut down. I've been joking that we somehow in the Bad River case and Michigan, we seem to have united labor unions and chambers of commerce because we have adverse declarations from both of them. And we also seem to be the one issue on which the United States and Canada both agree, because, again, Canada is firmly in support of the pipeline, as is our federal government, and they've both filed briefs with the trial court judge to suspend that shutdown date. Judge Conley's decision in that case was in part based on treaty rights, and his discussion of the merits and of treaty rights is very good and very strong. And one of the things he said was that this transit pipeline treaty cannot trump tribal treaty rights. The tribal treaty rights were first in time, and that if only Congress can abrogate tribal treaty rights, and it has to do so very clearly. And there's not a word in the transit treaty about tribal rights. So he issued a very good, strong decision on that point. And that now, really, our fate is in the hands of the federal appeals court. In Michigan, the tribes have raised treaty rights in opposition to the tunnel. Those arguments have been made. They were made to the Public Service Commission. They've been made to the Environment Department. We have some wonderful tribal leaders in the state, including President Gravel at Bay Mills, who is sort of the leader of the charge on the tribes side. And we will hope and pray that the state agencies, that Eagle pays the attention it should to the tribes to the tribes' rights. The Army Corps, again, I think it's pretty foreordained that it will not.
Okay, we're going to wrap up. We have time for one more question. Erica, do you want to cue that one up?
A lot of pressure. But I do feel like this is a really great question, just because I think it deserves a little bit more context. What was the basis for Michigan Public Utilities Commission to approve Line 5 with the environmental impacts? If you could just explain that a little.
Sure, it's a great question. I think it boils down to this. The Public Service Commission recognized, just like the Army Corps did, it recognized that the tunnel will have significant environmental effects. But what it did essentially was to gloss over those effects and to say the way it interpreted the Michigan Environmental Protection Act was to say, well, if we find that there are going to be environmental impacts, the next stage of the analysis for us is to consider whether there are any feasible and prudent alternatives to the tunnel. And if we conclude that there aren't feasible and prudent alternatives, then it doesn't matter if there are going to be environmental impacts. We are going to go ahead and approve the project. And that's how we read the statute. And there are two huge problems with that. One is we think they misread the law, and that under the Protection Act and under the Great Lakes Submerged Lands Act, which we think and this is really the flow appeal, has a very significant role to play in this case, that once you determine that there are significant environmental impacts, you can't excuse those based on the alternatives. And that's what the Michigan Supreme Court is going to have to decide, and what we're going to be arguing to it. The second thing is that if you do look at the alternatives, we think the MPSC just really engaged in a distorted alternatives analysis based on very outdated information. And many of you know this and have heard these studies, but there's a great report by the PLG group from 2023, which is the most independent, exhaustive study, which shows that even if one is intent on replicating the oil flow from Line 5, and one wants to burn down our world, and that's the test. You can replace the market can and will replace Line 5 oil through other less environmentally threatening means. But the MPSC ignored all that and sort of bought into two things. One, Enbridge's argument that only Enbridge pipelines can supply this oil. Two, that it's an imperative to supply all this oil. And three, that the tunnel is a safer alternative than running the dual pipelines. And that's an argument we really all need to contend with and continue to contend with. And we get asked this question all the time, like, isn't the tunnel safer than having the existing pipelines? And I'll end with this but it's a point I really want people to think about and understand because it does get raised so often. I anticipate that we might even get asked this question by the Michigan Supreme Court. It's a false dichotomy. For one thing, building the tunnel ensures that the existing pipelines will stay in the water for at least another decade because Enbridge estimates that it will take 6 years to build the tunnel. That's clear, almost certainly an underestimate. And once one factors in litigation challenges, you're talking about at least another decade where you've locked in operation of the dual pipelines. Secondly, the chambers of commerce and others argue that permitting the tunnel should be relaxed so that we can get these dual pipelines out. That's akin to saying that a corporation like Enbridge that is engaged in environmentally reckless and threatening behavior should somehow be rewarded by being given more lenient and lax permitting scrutiny, which is exactly how we ended up in this problem in the first place. In the 1950s, state agencies did very little in the way of environmental review before approving Line 5. And now our generation is dealing with this problem. And I'm so appreciative of everybody on this call and this group is fighting so hard to ensure that history doesn't repeat itself and that we don't make the same mistake for a future generation to have to deal with.
Thank you so much for being here tonight. We really appreciate it. If anybody has additional questions, feel free to continue to put them in the chat. We'll do our best to answer them as the call wraps up. I'd now like to ask Nicole to briefly share more on the EPA's proposed rule changes to the Clean Water Act and the impacts that could have with Line 5. We'll drop the action in the chat here also. The QR code's up on the screen. Nicole?
Certainly. Thanks, everyone. So again, with what was being said about kind of taking decision-making authority away from the states as a tactic and a strategy to, just double down on big oil getting whatever they want and what they paid for with our, many assorted politicians. EPA is, got rid of purged a lot of scientists and career civil servants and has at the head those who are doing the bidding of the current administration. So they want to narrow what states and tribes can consider when it comes to permits that have, even though a federal project will have negative effects on the environment, they want to take authority away from states and tribes to have any input saying like this project is problematic because it harms our waters. It threatens our water quality. So we have that action that Julie put in on our website, and the Section 40, the rule that they're trying to change, it is a hard one. Section 4.1 is hard one to get to advance the say that tribes in particular have on this decision making. And so, they just the typical language of like ease the permitting process, the favorite cut through red tape. That's just the approach they're taking. But it, at the end of the day will undermine what the Clean Water Act is intended to be and leave any questions about public health, about the viability long-term of our ecosystems, just out of the conversation. So please do take that action. There was very much under the radar. It's pretty shocking. It's only a 30-day comment period. It's pretty unheard of for such a impactful kind of proposal. So we need to do what we can to get as much public feedback as possible and let them know that eyes are on them and they can't sneak something through like that. So thank you.
Thank you. All right, the link is in the chat, and it's also on the Oil and Water Don't Mix website under Take Action. We appreciate you taking action and share it with your friends, with your network online on social media. The more people we can get to take this action, the better. And that's it. Thank you for joining us tonight. We'll be doing a live stream in March around the Michigan Supreme Court case and the rally in Lansing. Stay tuned for more details on that via email and on social. And then our next campaign briefing will be in April from 7 to 8. It's not on the website yet, but event page will be going up soon. So we hope you can join us then. And don't hesitate to reach out to any of us organizers in the meantime with any questions or anything like that. And we appreciate you taking the time on your Tuesday evening to join us. Have a good night.